Welcome back, everyone. You may not think it'll happen to you, but if it does, would you know your rights if you were laid off? So far this year in Texas, there have been more than 145 WARN Act filings impacting tens of thousands of workers. Here to help us understand those is Sean Timmons, managing partner at Tully Rinke, breaking down what those WARN filings mean and the rights that employees have if they're facing a layoff. So, Sean, thank you so much for being here.
Well, thank you for having me. It's a great opportunity to speak with you. I appreciate it.
It's an important conversation. So for viewers who may not be familiar with the term, what is the WARN Act? When does it apply?
Well, the WARN Act is the worker adjustment law that protects employees of large organizations. So it applies if you work for a company in private practice with 100 employees or more. So you have to meet the statutory threshold for employees, meaning you have to be with an employer with over 100 employees. Those small businesses would be exempt from WARN Act compliance.
And what kind of protections does that act avail to employees who do fall under that category?
The protection is basically notice to give you an opportunity to have time to transition to a new employment opportunity. Employers are required by law to provide 60 days advance notice for any mass layoff. Now, this is often litigated because there are exceptions to that notification requirement. The exceptions, such as unforeseen business interruption, natural disaster, or other unforeseeable circumstances, is often litigated heavily. So if a company is reliant exclusively on one vendor and that vendor shuts down and now they have no more business, they may have to abruptly stop operations immediately. So they may be exempt from compliance, but that issue is fact dependent and fact specific to each individual situation. Generally, if it's like Ford and they're a major plant and they're going to shut down operations, they have to comply with the WARN Act and say, okay, we're no longer going to build trucks in Austin, so we're shutting down this plant. They have to provide 60 days of notice, especially if they're going to continue operations in other locations or they're going to offer individuals transition opportunities.
That time might be so important to those employees. So what should someone do if they believe their employer may have violated the WARN Act?
Well, absolutely seek the intervention of legal counsel, because one of the benefits of the WARN Act is attorney fees are eligible for compensation, meaning if you hire an attorney to go after the company for violating the law, you're entitled to full recoupment of all your attorney fees and costs associated with pursuing the litigation. So generally speaking, individuals may only lose a month of pay, say if they only got 30 days of notice. Well, if they're only making a few $1,000s a month and they only lost 1 month worth of damages, then they may not have a very large claim. It may cost more money to hire an attorney than the money they actually lost in their lost salary. However, if individuals collectively join forces and file a class action lawsuit, collectively as a class, they can pursue remedies and relief, and their attorney would be entitled to compensation associated with that representation. What all that means in English is, even though your value of the damages you suffer may be low, the cost should be zero to go after the company to recoup your damages. And it's not just wages you're entitled to recover. You're entitled to recover medical benefits and other collateral benefits associated with the deprivation of your employment. So if you were relying on health insurance and now you got to go out to the economy and pay $2,000 in premiums, that's part of your damages in addition to your lost wages.
What information should workers hold on to, or documentation, if they either believe they are about to be laid off, if they've received a WARN notice? What would be helpful for folks to know, to have in their back pocket as they enter that next stage?
Very good question. Sometimes companies try to obstruct enforcement of this legislation by breaking themselves into sub-entities and having different individuals all in one location working for different entities. Oh, well, you work for X company, you work for Y company, you work for Z company. Courts will say that's a fraud. If they're all basically being paid by the same place, the same person, they're all one structure, one entity. So often you see major conglomerates try to have 10 different subsidiaries and obstruct compliance requirements with WARN by saying, oh, well, they're all different companies and none of them met the criteria for 100 employees. Well, if they're all being paid by, say, IBM, and it doesn't matter, there's 10 sub contracted locations or independent entities. They're all part of the same group working for the same major employer. IBM would be required to comply with the statute. So look for those issues to make sure that they do meet the criteria for 100 employees. Make sure the notice was provided and sufficient notice was given, and look for also any paperwork they shove in front of you saying, oh, we'll give you a severance, but you have to sign away all your rights. Make sure the severance you're offered, if provided, is sufficient to meet the criteria for the WARN Act compliance timeframe. So if they offer you a 2-week severance, but they gave you no notice, well, you're actually losing out on 6 weeks of pay. So you want to make sure any severance you're being provided or offered is legitimate and sufficient to actually compensate you for the full damages you're entitled to. I see a lot of companies, they try to browbeat individuals into taking say a week's pay and assigning an agreement that waives all their rights, and that gets them out of having to comply with the WARN Act. But if you do sign a release and you agree, okay, I'm going to take this money and I'm not going to come after you, well, then they may be off the hook. But they're entitled to a minimum of 2 months transition time before the layoff takes effect. So be very mindful of any contract or any document they want you to sign in exchange for money. You're entitled to that money of 60 days of pay, regardless if you sign any kind of contractual stipulation saying you agree to waive your rights. Never waive your rights without first consulting an attorney, having an attorney look at the paperwork they're presenting to you to make sure you're protected fully and that you're getting the full benefit the law provides to you.
Sean Timmons, managing partner at Tully Rinke, such important advice. Nobody wants to end up in that situation, but we appreciate the insight.